Hi, everyone. Thanks so much for joining us again. This is Camille with Caliber Home Loans, and I'm joined by Erica Carter Walden with Pacific Playa Realty. And this is a continuation of our probate series where we talk about properties that end up in probate, what you can do to help avoid it, what are some of the steps that are necessary to take. And so today's episode is going to be talking about the difference between full authority and limited authority. Erica is our expert. Not only is she a real estate agent that specializes in probate sales, but also she is a probate attorney. And so she comes with just a wealth of knowledge and experience and understanding about these transactions. And welcome, Erica.
Hi.
And before we dive in, I just kind of wanted to share a little bit about how I'm really excited to hear more about this. I had the opportunity to attend one of your seminars that you hosted earlier this year with Pacific Playa Realty, where you talked about probate transactions, and you delved into that difference between the limited and the full authority. And right after I attended that seminar, I found myself in a probate transaction. And so I felt very educated and you know, I knew the right things to ask and I knew the right things to say to be able to address the agents, and coming from a place of, you know, even if it was recent knowledge, but to be able to ask them the right questions. And I really had the appreciation for people who know what they're doing, because unfortunately I didn't have the confidence of that these agents knew, you know, the difference. And I know from a lender's perspective, even when we're dealing with trusts, or if there's a business entity, you find this a lot when you have flipping properties. You have a business entity that owns the property and they're selling it to an individual, and you need certain documentation. You need to show, like, if there's a trust, you need to show that the person is authorized, you know, to be the signer on the trust. And so I found myself asking them, the agents, those questions based on some of the feedback that you had given. And so my point is that I found it very helpful. So I hope that others find this segment as beneficial and educational as I did.
Well, thank you for that. I'm glad that I was able to inform you, and I'm glad that you were able to use the knowledge and the training. Yeah. It really is important for me to educate other agents and to educate the administrators and executors about what's going on. Because when you know what to do and you are able to do it correctly, then the transaction goes much smoother. It's really challenging working across from somebody on the opposite end of the transaction, from somebody who doesn't understand probate. I've had everything from, you know, people saying, okay, well, let's just sell the property. And thinking, okay, well, wait a minute, we can't do any of those things just yet. You don't even have authority to do that. Or the court needs you to do certain things, or the lawyer needs you to do certain things, or, you know, they don't understand. And there's so many moving parts to it. You know, and people submit probate, if I was a listing and somebody submits a probate offer, they sometimes put it on the wrong document because they don't understand or they don't know. And so then that takes time to go back and kind of explain to people, you know, this is what you should be doing. This is what you should be doing. And so it really helps me. It makes me feel good that I've actually given someone some knowledge and some tools to be able to go forward and use it. Because when everybody understands, it makes it a lot better.
Well, not only that, but based on that, I was also questioning escrow. I was saying, where are your attorney documents? It made the buyers feel uneasy because this wasn't an agent that they had built a relationship with. It was one of those, you know, classic kind of situations. They found a property, they contacted the listing agent, and the listing agent put them in touch with another agent that was in their office. But none of them had the experience all the way down to escrow. You know, when I started asking, you know, who has authority to sign on the behalf, I need, you know, not so much the power of attorney, but whatever it was, the documents that I needed to request, or just the attorney's letters. And escrow was scrambling like, oh, this is a probate transaction. Oh, I need to get this. And oh, I need to get that. I'm going, oh my gosh, you know. So we ended up actually backing out of the transaction because the buyers lost the confidence of the agents. The buyers didn't have confidence in the agent's ability, nor escrow, because the agents didn't notify escrow properly. And, everybody's working really fast and didn't really pay attention to the paperwork and realize this is a probate transaction.
That's the first thing that comes out of my mouth. When I have a listing and I send it to my transaction coordinator, because I try to get the transaction coordinator, which is the person that, helps gather all the documents, coordinate all the signatures for everyone. I send them the listing agreement, and even though it says it on the listing agreement, I specify it in the email. When I talk to escrow ahead of time and tell them, okay, we have this listing, we're hoping to put it into transaction soon. We are designating you as the escrow company. I need you to know that this is a probate. So this is what's coming. So I put that in not the header, but in the body of the email. Then I attach the documents. It needs to be flagged very early on. And we'll talk about why, because I have 2 transactions right now that will be good as examples. So that's a red flag that it wasn't flagged as a probate, because there's different documents, as we talked about in some of the previous videos. The listing agreement is the same, but you have to check certain boxes, and you have other documents that need to be attached to the listing agreement. And then on the buyer side, it has to go on a special probate purchase agreement. But then if you're selling a multifamily property, it needs to have an addendum. You can put it on the residential income purchase agreement, but you have to have a probate advisory that goes along with it, because there's certain things that the estate does not have to do in probate, like a natural hazard disclosure, but the buyer should do it anyway, but the probate is not required to, because it's probate. They're exempted from it. There's certain exemptions. There's all kind of things that you need to know. And so this is the first thing. So the transaction coordinator is going to be asking for documents. The administrators are exempt from a lot of things. So instead of certain documents, you get an exempt seller disclosure. There's a whole list of documents. And then title is going to want a whole lot of stuff. So
let's get into
thing.
it. Yeah, so let's get into the comparison, because you and I can talk shop all day long.
Yes. So we'll just start as to put things into perspective. An initial in a regular transaction, you have a listing, you have the listing agreement, you find a buyer, you advertise and market the property, someone offers on the property, or hopefully multiple people offer on the property. You identify the buyer you'd like to go on a transaction with. You negotiate the price, and then you sign your contract, price and terms, and you sign your contract. They go into the transaction, they do their inspections, you negotiate any credits or repairs, you move on with the appraisal if they're not hard money. If they have a loan, then you go into your loan contingency, you remove all of your contingencies, you move forward to close of escrow. That's just a streamlined non-probate transaction. A lot of other things happen, but that's a streamlined non-probate transaction. In a probate, you have, and we talked about this in an earlier video, a couple other videos, you have the option to do either limited authority or full authority. So if you opt for limited authority, or you request full and the court gives you limited authority, for whatever happens, you end up with letters that are for limited authority. Your sale is going to require court confirmation. So that means that you cannot, whenever you enter into the contract, so you identify a buyer, you market the property, you identify who you want to go into transaction with, and you take that offer, but that offer is not set in stone. That offer is the offer that you take to the court, so that you send that offer to the attorney then requests a hearing, and that hearing date that needs to be published. So they have a whole publication that they have to do. And as the agent, I publicize it on the multiple listing service, that it actually, we have a court date. The overbid amount is, and I'll tell you what that means in a minute. The overbid amount is, and it's telling any and everybody that they can come to court March 15th and outbid whoever we went into contract with. Now, if nobody shows up, then the buyer that we went into contract with wins. But if people show up, it's an auction. in the courtroom. So backing up a little bit, when you take your listing, you don't just go by the comps, which is what's normally done. We look at the comps, we look at the comparables, we look at the condition of the property and the location, and we determine a price. We can't do that with a limited authority listing. We're definitely going to look at the comps and the condition and to see how our property measures up against what's on the market. But we have to wait for the probate referee to do their appraisal of the property. So they're going to do an appraisal of date of death value of the property. So if the person died in March of this year, then the appraisal is going to be as of March of whatever day March 12th, 2020, right, when they passed away. Okay. There are some cases, more than a few, where the person dies or has died a while back. So they'll do the date of death appraisal, and then they'll do a reappraisal for sale. So they may have died 12 years ago or 20 years ago, and let's say they died 20 years ago and the property was worth $100,000. Well, we're not going to market it for $100,000. We're going to market it for today's value. So they're reappraising the property for today's value, and we're going to use that property value or that appraisal. We have to set our listing price within 90% of that appraised value.
For the current market value.
The reappraisal for sale. Okay. Value in that situation. Mm-hmm. If they just passed away, it's the normal appraisal that we're working with. The property has to be sold within 1 year of that. Got and if not, then it needs to be reappraised. So I have a property that's been on the market for a while. The family can't come to a decision on selling, on how to move forward with the offers that we have. And so if we don't act quickly, we're going to have to do another reappraisal, because it's not within the one we have now is going to expire. It's been a year.
So is it in this example, you got the appraisal done right after the person passed away or within a short period of time after the person passed, and now that almost a year has closed, you're approaching that 1 year expiration date from that appraisal. So now you're facing the possibility that you're going to have to get another one.
Yes.
Okay.
Yeah. And the estate pays for it. So you have to pay the appraiser.
Yeah.
And they get paid before you get a distribution. Right. So now you're racking up fees. You have to pay the lawyer. You're now having to pay for 2 appraisals because you delayed. So assuming that we're all acting in a timely manner, we filed our probate after the person passed away. The property's been appraised. The probate referee does not go in the property like a standard, lender appraisal. They run their comps. It's essentially a desktop appraisal.
Right. So
they run their comps. They may drive by, may not.
Okay.
And then they come up with their value, and that's what we have to work toward. So if they say the property is worth $700,000, we can't list it for over 90% less than that. Like, we can't list a property for $500,000. It has to be within that 90% margin. But that's kind of a holdup, because you have to wait for the probate referee to do that before you can put the property on the market, because they are determining your list price.
Got it. So when you say within 90%, so given that example, if it's 700,000 is the value, does that mean that you can go up to 770? Like, you can add 10% up, or you can't exceed the 700?
You can sell it for as high as you want. Like, they're not trying to cap the income to the estate. What they're trying to do is prevent people from selling at a loss.
Oh, okay. Got it. Okay.
Yeah. So you have to.
So it means you can't
undersell. You can't undersell the estate.
Right. Okay.
So there have been situations where they've done a desktop appraisal. They've evaluated the property. Let's say it's $700,000, but because they have not gone in, once you walk into the property and you see the ceiling is caving in, the floors have been stripped, like somebody has taken a hammer to the plumbing. Well, now we have to go back to the court, and we have to file for an amendment to the appraisal with evidence showing that this is not
Right.
This is not a $700,000
Right.
property. This
Right.
property value is, and
Yeah.
then we produce our comps with photos and things like that, and we ask the appraiser to amend the appraisal because we can't justify that price.
Mm-hmm.
So, but that's another fee. That's
Mm-hmm.
more fees, and you haven't even put the property on the market yet.
Mm-hmm. Mm-hmm.
So you've listed the person has passed away March of this year. You were appointed administrator.
Mm-hmm.
We'll say in this hypothetical, you'll be an administrator. So you have your letters of administration. The probate referee has done their appraisal. We've listed the property for, let's just say we listed for the appraised value of $700,000. We market the property and we get multiple offers. People offer, at and above list price. Say our highest offer is $750,000. We're hopeful that we were able to show the property, which is not always the case. Sometimes the properties are occupied and getting access is a nightmare, to say the least. But we're in this scenario, we showed the property and people like it, and they offered, the highest offer was $750,000. When we decide to go with that offer, we're going to take the offer and we're going to have our offer close of escrow to be X number of days after the court's hearing, because we don't know our close of escrow date until we get our court hearing date. And once that hearing date happens, we need to allow a few days for the paperwork to be processed, and then we can close escrow. So it can be 5, 10, whatever days, but we can't say a date certain on our agreement, on our purchase agreement. It has to be a certain number of days, or I write it as a certain number of days after the hearing on the court confirmation. So we take that contract and we send it to the attorney. The attorney then files a report of sale and petition for order confirming sale of real property. That's a mouthful. I had to read it because I always remember, I was like, it's a order confirming sale. That's how I think of it in my head, but it's officially the report of sale and petition for order confirming sale of real property. So they take that, they attach the
purchase agreement,
and they submit it to the court. And then the court sets it for hearing. And so the hearing date will be calendared. The information and regarding the hearing and the proposed sale will be published in a newspaper. We're still publishing here because this is a public process. Hearings before COVID are typically 45 days from the filing, not right now. If you file something today, you're almost guaranteed you're not going to get a hearing date until next year. And I don't know what part of next year, but it'll be like, I don't know if it'll be January. I don't know.
October right now, just as a point of reference, right?
Yeah. So, people are filing things now and they're not getting into court until January, end of January. It could be February, depending on the courtroom. We also have holidays coming up. So it was 45 days. It's not that right now. Now, hopefully it'll lighten up a little bit, but it's just not that right now. So you'll take the information that's being published, and a good agent will put it also on the MLS and specify court confirmation hearing date is, and they should tell you in what department it's going to be in. Department is the room that the matter is going to be heard. If they know the department number and the room number, you can publish that too, but just as long as people are able to find it. They'll be able to go by the probate case number, and then they'll tell you what the overbid amount is. And I'll tell you what that calculation is in a minute. So the judge will call the matter on the day of the hearing. Say it's January 15th, that's your court confirmation date. The judge will call the matter, and depending on the courtroom, they will ask anybody who's there to overbid to sign a note or a document or some sort of form so that they know how many overbidders there are, and the court can prepare accordingly. Other courtrooms, they'll just announce when they call the matter to be heard, hey, anybody here to overbid? Anybody here to overbid? Okay, come on up.
So just so that I follow and I understand, and also so that viewers understand. So what you're saying is that you have your offer, you've listed the property, you now have an offer of 750,000. You now have your court date. You go to the court, and during this court proceeding, there are people, almost like an auction. People can come and say, well, I want the property for 755, or I want 775. Is that what you're saying takes place?
Yes.
Okay.
It's a public auction. I mean, they're
Okay.
not like going, here, they're not doing that.
But they're still able to, raise their hand or whatever the process is and say, I want to bid above what this existing offer is on this property.
Right.
Okay.
So for properties that are like $500,000 and have a lot of upside, you may get a lot of people. For lots that may have a small house and like several other not acres, but half acres or whatever, it might be zoned favorably, you might get a lot of people. I mean, I've been in court where there's like people are overbidding in the millions.
Oh, wow.
So it's, you can see it's an auction.
Right.
And so the court will, however they handle it, have you either specify when you get there, we're here for matter number 3, we're overbidding. And the court will call everybody up once it's time. Okay, we're hearing matter 3 on the court calendar. Come forward if you're interested in overbidding. Okay. And so the judge will then look at the contract, and the first overbid, which has been publicized by now, so everybody understands. The first overbid is to be at least 10% of the first 10,000 of the original bid, and plus 5% of the amount in excess of that 10,000. So it's easier to do that in numbers. So we'll do a small number. Say we went under contract for $100,000. Okay. The first $10,000, so $10,000, it has to be 10% of that $10,000. So that's $1,000. And then it has to be 5% of the remaining. So 5% of $90,000. Okay. 5% of $90,000 is $4,500. So your first overbid is a combination of those two numbers. So your first overbid is the 1,000 plus the 4,500. So that's 5,500. So your first overbid is $105,500.
Okay.
So you'll rewind the video, or you'll talk to me on Facebook Live when we do the live. You can ask me questions about this, but just using simple numbers is it's 10% of the first 10,000. So in this scenario, 10% of 10,000 is 1,000, and then it's 5% of the remainder over that. So we only had 90,000 at that point. So 5% of 90,000 is 4,500. So you combine those numbers, and it's 5,500 plus the original contract amount. So it's over the contract amount. So that's what the first overbid has to be. So if anybody's in the courtroom to overbid, the judge will start. Okay, any overbidders? Great. The first overbid amount is $105,500.
Right.
Any takers? And people will raise their hand.
Right.
Then the court sets the increments after that. Okay. And they just make a decision. Okay, we'll go up another 5%. We'll go up another, whatever it is, until there's no more takers. And at that point, the winning bid will have to provide a cashier's check for, the deposit of that. And then they'll give us the contract information, because if it's not the original person that went under contract, you have a new buyer. And so we have escrow has to do get a whole nother set of documents. So we need to we'll go out in the hallway, the lawyers, the lawyers and the real estate agents and the buyer and the seller. Many times they'll have a representative, like if it's, but usually everybody
over that. Yeah. Like if somebody has that kind of question, they can get a little bit more into that minutia of those details of what happens there. Okay.
Either way, if you win, you have to have the money.
Right, right,
And you're going to
right,
swap out at that point. You have to get some information. The court will write an order, and that's why you
right,
need a few days. You can't close immediately after the
right.
hearing because escrow has to get some documents, has to release the other buyer's funds and all of these other
Yeah.
things.
Okay.
So the major difference here is you have to go to an auction. You have to be overbid.
Mhm.
It's a full court proceeding.
Mhm.
You can't set your own list price. You have to wait for the probate attorney, the
Mhm.
probate referee to determine your list price. And that can actually get people to be disinterested. I can't think of the right word. Not detract, but
Discourage people.
discouraged. Thank you.
Right.
It can actually discourage some buyers from actually looking at your property because
Okay.
they don't want to go through the overbid process. They want to just write an offer and have the offer accepted and then move forward.
So this is if it's full authority. Excuse me. This
So
is
this
if
is
it's
if it's limited
limited.
authority.
Yeah, this is if it's limited. So just kind of like you're saying how buyers, because a lot of times we get those questions. It's a probate, either from a lender or even from an agent's perspective. You get a buyer that, sees a property, it's listed lower, so they're excited, and it's a probate, right? It's kind of same thing when people see short sales or foreclosures. They get excited, it's a lower price, and they're thinking, okay, I can go for this, it's affordable. So when either the buyer, the agent, or as a lender, when you have somebody that is interested in a probate property, sounds like the first question that needs to be asked is this a limited or is this a full authority type of probate? I almost said probation type of probate transaction, so that so as the buyer, not only that, but all of the parties involved, whether it be the buyer's agent or the loan officer, we understand what is going to be involved. Like what you just said, is this going to become like a lengthy court process, or as a full limited authority, meaning that the seller who was taking over the sale of the property has limited authority of being able to set the price, sell the property at that offer that they've received, or do they have to go to the court and go through all of this process?
Right. So the question is typically very easy. The question is typically, does this probate require court confirmation?
Okay.
And that's it. And
Okay.
yay or nay determines whether it's limited or full authority.
Okay.
So that's typically the question. Does this
Okay.
probate require court confirmation? And
Okay.
that answers a lot of questions
Okay.
there. I was going to say something else, but it'll come to me a little bit later. Regarding the limited authority. It'll come to me later.
Okay.
But that's basically it in a nutshell, that you have, oh, I know what it was. Once you win that bid in court, that's it. You don't have any contingencies. You don't have a loan contingency.
Right.
You don't have an appraisal. You can't get an appraisal. You can't get a loan. And if it doesn't come through, then you own that property. It is yours. Sorry. If you didn't get in to see it and the showings, and once you get in to look at it, you're like, oh, I don't like this, too bad. You own the property. It is a non-contingent process. When you show up at that court and you make your bid and the judge says it's yours, whatever it looks like.
So two thoughts kind of come to mind, not only from the buyer side, but also from the seller side. Is there any vetting of the people that are bidding on these properties? Whereas like when you go to an auction, you at least have to show a letter, from some type of financial institution or bank statements or something to show your ability to be able to offer $500,000 cash for this property. So is there any type of vetting from the court's side that if a buyer shows up and says, okay, I'll bid that 105,500, now the property is mine, what if I'm not able to perform?
So they're supposed to show up to the court with a cashier's check. They're supposed
for the full amount, for some full amount of thereof.
Yes.
Okay, got it. Okay.
So you're not supposed to just show up empty-handed in your suit looking cute.
Right.
You need to come with a cashier's check, not a personal check, not cash. You need to come with a cashier's check.
Right. Okay.
And so presumably, or it's been my experience, this is not always the case, but it's been my experience that the people that are overbidding, I've already vetted anyway. They are the ones that lost out on the original purchase. They're the ones that we didn't go into contract with.
Got
And
it.
so I've seen their financials,
Got it.
but again, that's just a limited amount of people. If it's a really hot property, people can just show up it's a public process. I can just show up with my cashier's check for $1 million and say, hey, I can buy it.
Right.
But in my situations, I've seen, I've usually, the people who are overbidding are people that I've already been in contact with.
Got it. Okay.
And you as the agent you're still marketing the property. So if you can get the estate more money, you went into contract with one buyer, but you're calling everybody else saying, I know that we didn't accept your offer, but the overbid is here. Would you like to overbid? The court date is here, because you're advocating for the estate. You want to get as much money for the estate to take home. It's your fiduciary duty to,
so then
do what's
why
best
wouldn't
for
you
the
have
estate.
accepted one of those other offers in the first place?
Because they may not have offered the best price and terms, but now that they lost, they may say, I still want it. It's in for $750. I think I can go up to $800. I'll give it a try.
You also bring up a really good point. This is one of the few exceptions in real estate as a listing agent that you're able to divulge exactly what your accepted offer is.
Right.
Okay. So then, so come back a little bit and talk about how, at what point does the court decide? So we've talked about you're the executor, and you've got your attorney, blah blah, and you've now listed the property. Or at what stage does the court decide whether or not that executor is going to have full or limited authority?
Oh, when you get your letters of administration clearly state on there if it's full or limited authority.
And are there any key deciding factors? Like, what goes into deciding whether or not you're going to have full or limited?
Some of it is you're asking for limited because you don't want to pay the bond amount versus limited versus full is a lot more money.
Okay.
The bond is a lot higher. So you may not want to pay the bond. You may not want to incur that expense. You may ask for full authority and the court may say no, because you may live, somewhere else, may not really have a job, and may have a lot of people that are relying on this asset. So they may say, I don't really know about you.
Okay. Okay.
I've had a client that he was borderline shady.
Mm-hmm.
I mean, honestly, he didn't reflect as a lawyer. He didn't reflect in the best light. He did need to probate the estate. And he got bonded, but he wasn't an A+ client.
Character.
And
right.
So his character was a little bit off. And so he got limited authority. And I think the court made the best decision with regard to that. So there could be a variety of factors. I mean, you can request limited authority, like I said, because the bond amount just may be high and you don't want to have to deal with that. You can request limited authority because you may think the property can get bid up, like you want to have an overbid process. There's a lot of reasons why you would have limited versus full authority. So
because I mean, it would seem to me that full authority would be more desirable because then you don't have to go back and forth to the court. So with that being said, talk a little bit about what happens with limited, because I'm realizing that I know what happens with limited, but just talk a little bit like coming back to, okay, now you've listed the property, now you have an offer. So what happens then?
With full or with limited?
With full.
Okay. So with full, real estate agents want full authority.
Right. Exactly.
Makes our life so much easier to have a full authority sale. If you call me, I'm going to ask you, the first thing I'm going to ask you is, do you have full or limited authority? Because that makes our conversation very different.
Right.
I would love if you have full authority, and I'll explain why. So You come to me, you tell me I have full authority. I say, okay, great. I get the property address. I run comps like I would in just a normal transaction. We have a conversation. I do a full listing presentation as I would do anyone for doing any other type of property, probate or not. I talk to you about the location, the condition of your property, and the price, and we suggest a price based on the other properties that are comparable, that are currently on the market, that you'd be competing against, and the properties that recently sold, that are, you know, basically we're going to compare apples to apples, square footage, condition, all of those things.
Right.
We determine a list price. We then set the property for list price. I publish it on the MLS, and I say that it's a probate with no court confirmation required. Okay, so that then people are like, oh, good, I can just offer on the property. So again, we're hopefully able, it's not occupied by someone who won't give us access. If we're able to show it, we show it. And we take all of our offers in, we do counters or whatever it is. We come to an agreement with regard to the highest, the best price and terms. Sometimes the terms will win the day over the price, and that's in a non-probate or a regular sale. So depending on what the best offer is in terms of price and terms for the estate, we'll go under contract with that person. But because it's a probate, I'm going to wait in a full authority situation until they've actually removed their inspection contingency, their appraisal contingency if they're getting an appraisal, and their loan contingency. I'm going to call the lawyer and say, we have this offer, but I'm not going to send you I'm not going to give you the nod to do the notice of proposed action. And I'll explain what that means in a minute until we know that they're going to move forward. So once they're non-contingent, I then send the purchase agreement to the lawyer and say, okay, we're ready to go. File the notice of proposed action. What the notice of proposed action is, you are again providing a notice to the world and to the beneficiaries that you had noticed previously for your petition that we have gone under contract and we intend to sell the property to this person. So the offer is not fully or the contract is not fully non-contingent, because the contingency here is that nobody from the family or the world is going to object. They're non-contingent with regard to loan, appraisal, and inspections, and due diligence, hopefully, but we can't hold them to a contract that we can't perform on. So if we can't sell the property, we're not going to keep their deposit and say, oh, I'm sorry, thank you for playing. That's not how this works. We need everybody needs to be fully informed that it still needs to go to court for the notice of proposed action. And then you have to wait for 15 days to see if anybody objects to the proposed action, which is the sale under this purchase agreement. People can object on the 15th day. You think you got a sale and you don't. And then if somebody objects, the court will then set it out for a hearing, and they hear why the person objects and all of those things. And so on a full authority transaction, you're saying that it doesn't require court confirmation, but there's very rare circumstances where you may have to get the court to confirm the sale because, you know, people are just objecting and they don't think the administrator did a good job, or they just want to be, you know, have their say so in it, and, you know, all of those things. So you're hopeful in a really good situation, a really good scenario, is that 15 days passes, and then you can say, okay, we're clear to close. You then call, you then let the buyer know, let the lender know, let escrow know we have our order from the court saying the sale is fine, and we can close escrow at that point.
Okay. And see, that was the one that I was in that I talked about at the top of this show, was that the transaction that I was in, it had recently been listed. They had another buyer that ended up falling out of escrow just because there was some issues with the condition of the property. And so then we were, you know, the backup offer, right? So we became the offer that they accepted. And, you know, as I mentioned, this transaction came on the heels of attending your seminar. And so I'm thinking what you just said, okay, even though we have an accepted offer, you have full authority, I kept saying, don't you have to file something with the court? Don't you have to publish something? Don't we need to notify the notaries, the attorneys rather, excuse me. And everybody was like, no, 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 it's no big deal. You know, I've done these all the time. It's not a problem. We're going to close in 2 weeks. And I'm just saying, something just doesn't seem right here. And I kept calling you and I was going, are they going to be able, is this right? And you were telling me, you know, no, they've got to be able to go back to the court or at least notify the court. It may not necessarily have a hearing. And the estate was reassuring me that there was very limited family. Nobody was going to dispute this. It was going to be an easy transition, which was fine. I mean, I wasn't so much concerned that somebody was going to dispute it, but my concern was the time frame. They were trying to rush this and they were trying to get us to hurry up and close. And I just kept saying, well, aside from the fact that there's some, you know, deficiencies with the property, but just the process, this doesn't sound right to me.
Yeah. So there are exceptions to the notice of proposed action. Mm-hmm. So I have a transaction right now where there is one beneficiary and he's the executor. Mm-hmm. And so there doesn't need to be a notice of proposed action. Mm-hmm. I've had one sale, and we talked about this before, where we could have received a waiver, but mm-hmm. you know, two of the three beneficiaries were willing to waive. The third couldn't because he was in prison and he wasn't going to be able to sign a waiver. Mm-hmm. But if all the beneficiaries are, you know, they sign a waiver, then you're okay. Or in this particular situation where there's just the executor is the beneficiary, there's no one to notify. Even in that situation, title wanted something from the lawyer on letterhead that said, no notice of proposed action is needed because he's the sole beneficiary and the executor and there's no one to notify. So title wanted that. Mm-hmm. Title may also want something from the attorney that says a statement with regard to estate taxes, like estate taxes are owed or they're exempted. So you have to keep the attorney in the loop for a lot of reasons, because title just needs documentation. They're providing title insurance, so they want to make sure that they've done their due diligence on this property. And so to say, oh no, we can close this in 2 weeks, and I didn't feel comfortable offering or giving you assurance that, oh yeah, it can be done, because I didn't know that I didn't know that if they could get waivers, or I didn't know what was going on.
Right.
Of course, my child is in the background now.
You know, it's real life right now. It's okay.
So, you know, it's one of those things where I didn't feel comfortable saying, I didn't know what was going on with regard to the facts. They had also been a little bit not forthcoming with other things, and that made me leery I just didn't feel comfortable.
Agreed.
You know, with you on that transaction.
Yeah, agreed. And that was the same message that I conveyed to the buyers as well, that you know, escrow doesn't know, the agents don't seem to know. This just doesn't seem as though everyone is, you know, just confidently, because there hadn't been enough communication with the attorney. And I think that was really what was the red flag for me, was that there wasn't enough communication. I'm the one who had to tell escrow, hey, this is a probate transaction. Do you have your attorney's letters? Have you contacted the attorney? And then also to your point about the title insurance, I mean, the whole purpose of title insurance is so that somebody's long lost uncle can't come out of the woodwork and say, hey, this was supposed to be my property. I mean, that's not the whole point of title insurance, but that's one of the important points of it. So if enough due diligence hasn't been done, or if you're losing confidence that these people are doing that, it's hard to confidently remain in a transaction and feel as though, okay, you're going to be able to take title to this property, and or not even so much that, but that we would be able to close in the rushed manner. And I think that was the other red flag. It was one thing to say, okay, you know, people just didn't notice, you know, it's human error, it's mistake, blah, blah, blah. Okay, let's get the attorney involved. But it was, why are we being pushed? What is the big rush? Why do we need to close in 21 days? something just doesn't feel quite right here, that we're
Yep.
being pushed on a transaction that usually needs, a few more checks and balances to close.
Yep. And I'm always leery of not keeping the attorney in the loop.
Hmm.
I'm just leery of it. I need them to know, like some attorneys are way more hands-on than others. Some are like, okay, you handle it and just send it to me when we're ready to do the notice of proposed action. Others want to be involved in a large part of the process. So I talk to them at the very beginning and say, just to figure out how involved they'd like to be. And then I notify them if anything comes up.
Hmm.
And the fact that they hadn't been in good communication
Right.
with the attorney, and that they hadn't been communicating clearly with you, and it was just too many red flags.
Right. Understood. Okay. So, to summarize for today, I hope that people were able to get a good understanding of the difference between limited and full, the pros and cons, the benefits, the downfall of one or the other. Obviously, if you have more information, Erica is your expert. I think it goes this way when we actually tape it. So, Erica is your go-to person. Again, she is a probate attorney, but she's not a practicing probate attorney, but she obviously can refer you to some excellent attorneys if you find yourself in this situation, but certainly is a wealth of information, extremely sympathetic to, your circumstances, understanding that this is not only a huge financial transaction that you're taking care of for you and your family's well-being, but also it's a major emotional transaction. And real estate can be complicated in and of itself. Certainly, this is one of the more complicated transactions that occurs in real estate, which is the whole purpose of us having these video series, to help people understand it, to help really unmask some of the mystery that is involved, and to let you know that you have a trusted person who will be there for you, help walk you through the process, and is there to educate you. And that's our big takeaway here is we want to be there as educators. It's not just about us, getting your business. Obviously, we'd like to be able to assist you with your transaction, but it's also making sure that you're informed, that you know what's going on. As I said, Erica has been extremely instrumental in educating me in this type of a transaction. So any closing remarks, Erica?
No, just call me if you have any questions, or message me. I think we're going to do a Facebook Live in a couple of weeks.
Yes.
So get some questions ready. I know this was a lot to absorb. Actually, every
Yeah.
video had a lot to absorb.
Yeah.
So kind of go back, gather your questions, and I'll be, ready to answer whatever you got.
Great. All right. Well, our contact information is to follow. So please don't hesitate to reach out to either one of us with any other questions. This is Camille with Caliber Home Loans, your Zen lender. And let's keep everybody calm in stressful transactions.